The Freedom of Information Act, 5 U.S.C. 552, is a federal freedom of information law that allows for the full or partial disclosure of previously unreleased information and documents controlled by the United States government. The Act defines agency records subject to disclosure, outlines mandatory disclosure procedures, and grants 9 exemptions to the statute. This amendment was signed into law by President Lyndon B. Johnson, despite his misgivings, on July 4, 1966, and went into effect the following year. As indicated by its long title, FOIA was actually extracted from its original home in Section 3 of the Administrative Procedure Act. Section 3 of the APA, as enacted in 1946, gave agencies broad discretion concerning the publication of governmental records. Following concerns that the provision had become more of a withholding than a disclosure mechanism, Congress amended the section in 1966 as a standalone act to implement a general philosophy of full agency disclosure. The amendment required agencies to publish their rules of procedure in the Federal Register, 5 U.S.C. 552, and to make available for public inspection and copying their opinions, statements of policy, interpretations, and staff manuals and instructions that are not published in the Federal Register, 552. In addition, 522 requires every agency, upon any request for records which reasonably describes such records, to make such records promptly available to any person. If an agency improperly withholds any documents, the district court has jurisdiction to order their production. Unlike the review of other agency action that must be upheld if supported by substantial evidence and not arbitrary or capricious, FOIA expressly places the burden on the agency to sustain its action, and directs the district courts to determine the matter de novo. The federal government's Freedom of Information Act should not be confused with the different and varying Freedom of Information Acts passed by the individual states. Many of those state acts may be similar but not identical to the federal act. Background: with the ongoing stress on both constitutional and inherent rights of American citizens in the added assertion of government subservience to the individual, some, particularly Representative John Moss, thought it was necessary for government information to be available to the public. This push built on existing principles and protocols of government administration already in place. Others, though, most notably President Lyndon B. Johnson, believed that certain types of unclassified government information should nonetheless remain secret. Notwithstanding the White House's opposition, Congress expanded Section 3 of the Administrative Procedure Act as a standalone measure in 1966 to further standardize the publication of government records, consistent with the belief that the people have the right to know about them. The Privacy Act of 1974 was passed as a countervailing measure to ensure the security of government documents increasingly kept on private citizens' scope. The Act explicitly applies only to executive branch government agencies. These agencies are under several mandates to comply with public solicitation of information, along with making public and accessible all bureaucratic and technical procedures for applying for documents from that agency. Agencies are also subject to penalties for hindering the process of a petition for information. If agency personnel acted arbitrarily or capriciously with respect to the withholding, a special counsel shall promptly initiate a proceeding to determine whether disciplinary action is warranted against the officer or employee who was primarily responsible for the withholding. In this way, there is recourse for one seeking information to go to a federal court if suspicion of illegal tampering or delayed sending of records exists. However, there are 9 exemptions. ranging from a withholding, specifically authorized under criteria established by an executive order to be kept secret in the interest of national defense or foreign policy, and trade secrets, to clearly unwarranted invasion of personal privacy. The 9 current exemptions to the FOIA address issues of sensitivity and personal rights. They are specifically authorized under criteria established by an executive order to be kept secret in the interest of national defense or foreign policy, and are in fact properly classified pursuant to such executive order, related solely to the internal personnel rules and practices of an agency, specifically exempted from disclosure by statute, provided that such statute requires that the matters be withheld from the public in such a manner as to leave no discretion on the issue, or establishes particular criteria for withholding or refers to particular types of matters to be withheld. FOIA Exemption 3 statutes. Trade secrets and commercial or financial information obtained from a person, and privileged or confidential personnel and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. Records or information compiled for law enforcement purposes, but only to the extent that the production of such law enforcement records or information could reasonably be expected to interfere with enforcement proceedings, would deprive a person of a right to a fair trial or an impartial adjudication, could reasonably be expected to constitute an unwarranted invasion of personal privacy, could reasonably be expected to disclose the identity of a confidential source, including a state, local, or foreign agency or authority or any private institution which furnished information on a confidential basis, and, in the case of a record or information compiled by a criminal law enforcement authority in the course of a criminal investigation or by an agency conducting a lawful national security intelligence investigation. Information furnished by a confidential source would disclose techniques and procedures for law enforcement investigations or prosecutions, or would disclose guidelines for law enforcement investigations or prosecutions if such disclosure could reasonably be expected to risk circumvention of the law, or could reasonably be expected to endanger the life or physical safety of any individual. Contained in or related to examination, operating, or condition reports prepared by, on behalf of, or for the use of an agency responsible for the regulation or supervision of financial institutions, or geological and geophysical information and data, including maps, concerning wells. The Postal Reorganization Act of 1970 exempts the United States Postal Service from disclosure of information of a commercial nature, including trade secrets, whether or not obtained from a person outside the Postal Service, which under good business practice would not be publicly disclosed.